factors that the court is directed to consider. I would point out again that the statute says you begin with a presumption of a PR bond. And, Your Honor, we think that is what he's entitled to. We had put in our memo a suggestion that he be subject to random drug testing. You know, he's willing to do that. He's committed to do that. He will do that regardless of this court's order. But, Your Honor, we think with random drug testing, that would be sufficient condition of release to ensure his appearance and that he's not a danger to the community. The Alex Murdaugh, who's not hooked on drugs, has lived a good, fruitful life and law-abiding life. Only when he got hooked on opioids did things turn south, and he truly regrets his conduct. Thank you, Your Honor.
Yes, sir. Waters.
Thank you, Your Honor. At this time, I would recognize Mr. Harry Bland, who is the designated representative of the victims in this matter. He would like to address the court. May it please the court.
Yes, sir.
Judge Newman, my partner Ronnie Richter and I represent the victims. These are the Satterfield and Harry family. This is Brian Harry. He's the direct victim of Alex Murdaugh. This is a sad day, Your Honor. It's a day for lawyers. We look upon another lawyer who stole money from clients. Alex Murdaugh stained our profession. He also put a black eye on this state. I disagree with Jim Griffin and Mr. Harpootlian. If he's an opioid addict for 20 years, how is it that he tried cases? How is it that he appeared before judges like you? How is it that he worked with his partners and represented clients? I do not believe that is the case. He is a clear and present danger to the citizens of this state and to my family. This is a man that used a gun on Labor Day weekend. This is a man that used a pen to steal $3.3 million with another $118,000 that's potentially going to be charged. It's no different than somebody walking into a bank and using a gun. We need to make sure that when somebody steals with a pen, it's the same as if they're stealing with a gun. We have a man here that you're going to hear from my partner has done some financial transactions within the last week and a half that shows that he is a financial risk to the victims of his crimes as well as the citizens of this state. Your Honor, we think that an appropriate bond should be placed, but it's a bond that has conditions, that he can't do financial transactions without court permission, that he, if he is going to stay on his property that's posted, that we have the ability to serve him with process. There's so many eyes on this courtroom today watching us. Today is the day that Alex Murdaugh needs to get comfortable getting uncomfortable. And I ask you to look at the crime. This is a crime of a lawyer stealing money. My partner and I have been doing legal malpractice for 30 years, and we have never seen such a breach of trust. A man who stole money from the very family of the housekeeper that helped raise his kids. This is a crime that we've never seen before. And I think Your Honor would send a clarion bell depending on the type of conditions that you put on his bond. I appreciate the opportunity to appear before you. The victims also appreciate you presiding over this case. And with that said, my partner Ronnie Richter will address it.
Mr. Bland, you're sort of vague on what you're presenting to me. On the one hand, you say that you're convinced that Mr. Murdaugh presents a clear and present danger to society and to himself, on the one hand. Then on the other hand, you say he should have a bond with conditions.
No, I want him not to have a bond. I would love it if this man was locked up and he couldn't harm anybody else. But there is a presumption that somebody is going to get bond. And if you're going to put bond, put those serious conditions on him that will restrain him. Our position is he does not deserve bond. He forfeited that right. He stole. He's a liar and a cheat. Thank you, Your Honor.
Yes, sir.
May it please the court, Your Honor.
Yes, sir.
Ronnie Richter, also for the victims. We want you to have the benefit or consideration of some of these transaction documents. We're not here to argue the case, but it does go to the nature of the crime. And in this case, you have a former member of the bar who brazenly used that office to lie and to betray clients, and also to demonstrate a pattern of a willful disregard for court orders. And I'll hand these to you at one time at the end of my comments, but, Your Honor, the case for us kind of starts with a petition that was filed for the approval of a $4.3 million settlement. There's many facts before that. But in this petition, it's very specific as to what's being asked and as to the disbursements that are being approved. And when Judge Mullen approves that petition by this order approving settlement, attached to the order is a very specific set of disbursements that were permitted from the $4.3 million. And Mr. Murdaugh would understand this as an attorney. By court order, the only disbursements that were allowed to be made from that money were set forth on this schedule, including a check for $2,765,000 that was to be directed to our clients as the beneficiaries of their mother's estate. So instead, what happens? They take this court order, they don't so much as file it in the court record, but they bag this court order. Mr. Murdaugh and perhaps others, and this, Your Honor, I'm going to submit for your consideration, is the trust account ledger from the Moss Coon Fleming law firm that shows exactly what happened when they left Judge Mullen's chambers. So instead of the disbursements on the order, instead of a check for $2,765,000 to our client, these checks issued. A check for $403,500, that's one of the checks that we're here to talk about today, to an account called Forge. And you've already heard, and I know Your Honor is well aware of Forge Consulting. Forge Consulting is the preeminent structured settlement firm in South Carolina. It's the place people go when they get large recoveries to invest and structure their money. Mr. Murdaugh intentionally set up an account in his own name, leveraging the credibility of Forge Consulting by calling it Forge. And so he directs others, write me a check and send it to a post office box in Hampton, South Carolina that goes without cover in the amount of $403,500. He takes that money, he misappropriates that money. Additionally, he requests that a check be issued to Forge for $2,961,931.95. You're not going to find that on Judge Mullen's approved schedule. That check, likewise, sent to a post office box in Hampton, South Carolina, under his control, takes the money, apparently misappropriates all of it. And as you've heard, there's yet another check for $118,000 that he requests and that's sent the same way. Your Honor, that is, I can't think of a more willful, open, brazen violation of a court order than that. When they walked out of Judge Mullen's chambers with that order, all counsel and Mr. Murdaugh understood what was to become of that money and willfully disregarded it. And so we have grave concern that whatever conditions you put on this bond, he will likewise brazenly disregard. That's why we're asking for tight constraints on him. Your Honor, I have copies of the actual checks. Significantly, on the $2,900,000 check is endorsed Alec Murdaugh, DBA Forge. So clearly, he misappropriated those funds to his own use in open violation of the court's order. Now, we have concern that he has been engaged in a pattern now of dispossessing himself of assets for the purpose of avoiding attempts by us and others to collect against him. We know that in recent times he has transferred an interest that he owned in Green Swamp Club, a gun club, hunting club down in Beaufort. We're not sure exactly what money he got for this, but the transaction occurred on October 1st, 2021, and I'll have a copy of that for the court's consideration. He is listed for sale a Grady White boat that he owns for $115,000. And more concerning and more troubling for us is he has granted to his son a broad power of attorney, surrendering all financial control to his son. So, Your Honor, if you do consider a bond, we would ask that that bond restrict the ability of his son to assist in the dispossession of assets that would otherwise be available to right the financial crimes that have been committed on our family. Now, finally, Your Honor, it's important to note that we're not the only victim. We're the only victims here today. Mr. Murdaugh's law firm has sued him for allegedly stealing $10 million, more or less. Now, amazingly, it's only at the time that the Satterfields came forward with their complaints that the Murdaugh law firm discovered for the first time that there's $10 million missing. Right? And what they explain on their website, and this is a notice that they published to the public on their website, is that all clients have been restored. No one has suffered a loss because of this. That is not true as to the Satterfields. Right? So if ability to pay is a concern for the court, apparently Mr. Murdaugh has enough wealthy and powerful friends and family members that somebody stepped in on his behalf to cure a $10 million wrong for him. Because that's what this represents to the world on the website. I can tell you it's not true as to our clients. So if you set a bond with a high financial amount, you should rest assured that he has the financial wherewithal through influential friends and family members to respond to virtually any bond that you could issue. So, Your Honor, we ask that you issue, if you're going to issue a bond, that it be for a serious amount. He has the ability to pay. And in closing, Your Honor,
What's the serious amount? 10 million, 20, 30, 50, 100?
$4.3 million feels appropriate to us. It seems to bear some relationship to the crime that was committed to our clients. And, Your Honor, in parting, there is one other victim in this courtroom you need to hear from, and that is the South Carolina Bar. Because I can represent to you, as a member in good standing and as an officer of this court, we get calls every day from lawyers about this case with one unified sentiment: outrage. You're outraged that this has happened, outraged that our profession is stained, and with the hope that the bench is going to start the process today of restoring some integrity and some dignity to the practice of law by letting it be heard that this conduct is unacceptable and that it will be met with the full force and fury of the court. Thank you, Your Honor.
Yes, sir. Mr. Waters.
Thank you, Judge, and thank you, Mr. Blaine, Mr. Richter. Very quickly, Your Honor, I provided a copy of this to the defense, but I do have for your consideration if I can approach a proposed order that's got some of these conditions for Your Honor to select or not select, obviously, based on Your Honor's ruling.
I'm happy to receive what anyone proposes. Wanted to be clearly stated that I'm not bound by any suggestions or proposals by either side.
Absolutely, Your Honor. The conditions on there are not selected, Your Honor. They're just the standard conditions, and again, you know, the ones that are of particular importance, aside from decent surety and GPS, is the wasting assets provision. He's already surrendered his passport. The no firearms provision is of significance, and the travel needing the approval of state is of significance as well. There's a number of other standard conditions that I think would be appropriate.
Mr. Waters, the statute provides that the arresting law enforcement agency shall inform the court of the various considerations indicated in the statute in Title 17.
Yes.
And I would like to hear from the law enforcement agency pursuant to the statute.
You would like to hear from me or the police officers, Your Honor?
You consider yourself the law enforcement agency?
Prosecutorial agency, Your Honor.
I'd like to hear from the law enforcement agency in charge with investigating the matter.
All right. We have Agent Turner, Special Agent Turner from SLED. He's part of this investigation.
Good morning, Your Honor.
Yes, sir. If you're speaking to the mic, I appreciate it, sir.
Yes, sir.
Good morning.
Good morning, sir. How are you doing this morning?
I'm fine.
Your Honor, I can say that we've worked in lockstep with the Attorney General's office on this case, and that everything they've said is completely accurate. We agree with their assessment of this case at this point in time, and we support them.
It's been indicated by the misled Chief that this investigation is one of a number of ongoing investigations. The statute provides that the court is to consider all incident reports generated as a result of an offense charge. And in my mind, the court should consider the nature and extent of any ongoing investigations that can be disclosed that might impact upon the court's decision. And how would you like to address that?
Give me just one moment.
May I consult with him, Your Honor?
Yes.
Yes, sir, Your Honor. I apologize. To put it clearly, sir, and right now what I can speak on, the South Carolina Law Enforcement Division, we are investigating multiple different allegations or investigations at this point in time, to include the Stephen Smith death, which you're aware of, the actual cause of Ms. Satterfield's death. We're looking into that, the financial case that you're here with today, and numerous other financial investigations dealing with fraud or possible other criminal actions. As of right now, these are the charges that we are comfortable with and that we feel appropriate bringing forth. That's not to say that there won't be additional charges brought forth in the near future or possibly brought forth in the future. But these right now are the charges that we, the South Carolina Law Enforcement Division, felt were appropriate to bring before you today.
All right, thank you.
Thank you, sir.
Anything else, Mr. Waters?
Nothing further from the state, Your Honor.
From the defense.
Your Honor, I hesitate to address Mr. Bland and Mr. Richter's allegations, but I think it's important for the court to understand. Mr. Murdaugh was not a lawyer in the Satterfield matter. He was the defendant. He had no authority over any money whatsoever. He was the defendant. The lawyer was a friend of his, but that lawyer's the one that issued those checks. That lawyer's the one that made sure the money went to this forge. He's the one that had responsibility, and then there's a personal representative who was a banker. They were responsible for making sure that Mr. Murdaugh could not, if he in fact did, purloin that money. So the idea that somehow he used his position as a lawyer, he was the defendant. He was the one that got sued. So make no mistake about it. In these particular crimes, he was not acting as an attorney, and that he was acting as a defendant. He got sued, or was going. They never actually filed a lawsuit, but he was the defendant. The insurance company treated him as a defendant. The insurance company decided what to pay. The insurance company wrote the checks. Number one. Number two, and I understand Mr. Richter and Mr. Bland are representing their client zealously, but that is a civil matter. If they want to deal with assets, there are ways to deal with that on the civil side, not on the criminal side. If they feel that he's disposing of assets, we don't know. I mean, they made some allegations here this morning. To be frank with you, he has been in rehab or in jail since he was turned himself in on the charges down in Hampshire County. He hasn't been executing documents except to the extent, I think the Hunt Club one you talked about was the bank getting paid. He got no money out of that. But again, that's for the civil court, not for this court. Be happy to answer any questions Your Honor might have.
All right. Before going to you, Mr. Waters, Mr. Murdaugh, is there anything you would like to say concerning bond?
No, sir, Your Honor.
All right.
Now, Your Honor, one other matter. He's not a member of the bar anymore. If the idea that somehow he could steal with a pen, he's not going to be in a position. He's been suspended. He's turned his license in. He's not going to have any escrow accounts. He's not going to have any clients. He's not going to be able to further the scheme that Mr. Bland and Mr. Richter talked about as an attorney. Thank you.
Yes, sir.
Your Honor, he absolutely used his position, his prestige, his reputation as a lawyer to steal from this family. They trusted him because they knew of his reputation as a lawyer. They listened to him when he took them to Mr. Fleming, and they believed in him when they talked to him about the case. PMPED sent a notice of representation at the beginning of this case, which is amazing. And at the end of the case, after that last check in October of 2020 for $118,000, there was a dismissal signed. It was signed by Mr. Murdaugh himself, not by any attorney on his behalf or anything like that. So it was his knowledge of the system, it was his knowledge of Force Consulting, and it was the belief of this family in his reputation as a lawyer that allowed him to steal this money. So it is absolutely tied to him being a lawyer. Thank you, Judge.
Mr. Bland and Mr. Richter, you indicate you have some documents you want me to review?
May it please the Court, Your Honor?
Yes, sir.
Your Honor, may I add one thing?
Yes, sir.
Mr. Arbulian is actually factually incorrect. Mr. Murdaugh prepared personal representative documents for Tony Satterfield to become the personal representative of his mother's estate. His paralegals and secretaries conversed with Corey Fleming's secretaries and paralegals about how money was supposed to be exchanged. He very much acted as a lawyer in this case. It's the strangest thing where the defendant dictates to the plaintiff lawyer how to run the case and then how to allocate the money in contravention of a court order. And we have introduced into the courts of this state the documents that show that Mr. Murdaugh actually did represent the family at the same time he was a defendant in a potential lawsuit. Thank you, Your Honor.
I'm going to take a recess to review what has been submitted and to ponder my decision. I'll say that I am not in any way considering a personal recognizance bond. I'm not considering that in any way. The issue for me is if the court should deny bond entirely. So we'll be in recess for about 15 minutes.
Thank you, Judge.
Oh, no ruling from the court, but an indication of where the court is going with this. Right at the end there, His Honor saying that he's not considering the personal reconnaissance bond, that he's now just considering bond or no bond. We're going to step aside, take a break. We're lots to talk about when we return. This is Court TV, your front row seat to justice. Stay with us.